Hello, everybody, and welcome to Law Bite number 116, dated November 25th, 2020. I'm Walter, your mobile historian and blue-collar scholar. This Law Bite is entitled The Seventh Amendment to the U.S. Constitution. Now, the Seventh Amendment to the Constitution is probably one that you haven't heard about very often, or heck, you might not have heard about it at all. And let's face it, it's not exactly as exciting as some of its contemporaries in the Bill of Rights, such as the First Amendment or the Second Amendment, all right, or heck, even the Eighth Amendment. The Seventh Amendment is kind of a dry part of the Bill of Rights, primarily known to people who love litigation, all right? So what exactly does the Seventh Amendment do? Well, simply put, the Seventh Amendment does two primary things. First, it protects the right to a trial by jury in certain federal civil cases, a great deal of them, I'll add. And number two, it prohibits the reexamination of any facts tried by a jury in any federal court, unless according to the rules of the common law. Now, the first part was probably very simple to understand, but the second part might have been a little confusing if you're not familiar with certain legal terminology. So let's read the amendment itself. The Seventh Amendment to the U.S. Constitution is as follows. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Did that help? It didn't? Okay. Well, if it did help, great. But for those who didn't quite digest that, I'll break it down even further. The Seventh Amendment, like I said, essentially contains two workable clauses. First, the Preservation Clause, where it reads in the beginning, at all suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. That's the Preservation Clause. Next, the Reexamination Clause. And in no fact tried by a jury shall be otherwise reexamined in any court of the United States than according to the rules of the common law. So we have the Preservation Clause and the Reexamination Clause. I'll talk a little bit about each. So the Preservation Clause establishes specifically the types of civil cases heard in federal court, which essentially are entitled to a jury trial, okay? Historically, this has been decided via the types of suits at common law that would have been tried by a jury according to the English common law in force in 1791 when the amendment went into effect. The Supreme Court, however, has interpreted the Seventh Amendment in recent times to include more than just the types of cases that arguably would have been heard via the English common law in place in 1791. Essentially, the amendment itself has been interpreted to any lawsuit in which the rights of the parties have yet to be determined. Okay, or were essentially to be determined. The rights of the parties have to be determined. Okay, now there are certain types of civil cases heard in federal court that are not included within the protections of the Seventh Amendment. Some of these include maritime cases, patent cases, and cases in which one is suing the federal government. Indeed. And you might wonder why that is. Well, Sovereign immunity, of course, protects the federal government from lawsuits, outside of it giving its consent to be sued. We'll talk about sovereign immunity in another law bite. But, the Supreme Court has ruled that when suing the federal government, the right to a jury trial is only guaranteed if, such a right is granted by Congress via statute. And the authorization of a jury trial in that type of suit must be very clear and unambiguous. All right. So most federal civil cases, are entitled to a trial by jury. Now, as with all protections in the Bill of Rights, they're not absolute. And as well, they do not have to be invoked. All right. You have the ability to waive such protections at any time. The right to a trial by jury in a civil case is a right, which means that the parties, may waive this right if they so choose, Indeed, when it comes to federal civil cases, the minimum amount typically in question must exceed $75,000. So any case virtually, and most of these federal civil cases, a great many, perhaps most, are heard under federal diversity jurisdiction, when people from different states are involved in litigation against one another. We've talked briefly about diversity jurisdiction in a previous law bite, but the parties, of course, have to reside in different states, and the minimum amount in controversy must be more than $75,000. So $75,000.01 and higher. When it comes to federal civil cases, like I said, this is not exactly an area in which the amount of attention surrounding it has been high. Indeed, like I said, it's probably something you've rarely heard about. So with that in mind, I'll move to the $20 clause. Now, scholarly thought on the $20 clause has been fairly consistent in that it was intended to become obsolete very fast and not to be interpreted literally. And indeed, in interpreting the $20 clause, the Supreme Court has ruled that virtually only certain types of cases may be heard with such a low threshold for the amount in controversy. But the vast majority of civil litigation heard in the federal courts would have to exceed $75,000 per se. All right. So only in certain lower types of cases, perhaps cases originating in the District of Columbia, all right, which is, of course, federal jurisdiction, might that $20 clause apply literally, to the case in question. All right. So with respect to federal civil cases, the Supreme Court decided in Colgrove versus Batten in 1973 that a 6-member jury, is the minimum, that meets the constitutional requirements to decide a civil case in federal court. All right. It could be more, but 6 members is the minimum. So that takes us to the reexamination clause. Now, of course, the reexamination clause, like I said, deals with the reexamination of facts tried by a jury, in any case decided in federal court. Now, according to the rules of the common law, all right, the only acceptable method of reexamining facts decided by a jury essentially is the court itself, where the case was decided, ordering a new trial, once again by jury, if the parties consent to that, or an appellate court ordering a new trial, once again by jury. Under the rules of the common law, a judge could not re-examine those facts and then render a decision. No. The only type of method acceptable to re-examine jury facts, all right, would be for a new trial to be ordered. Of course, like I said, a judge could, of course, nullify a verdict if it was determined that the jury had decided a case erroneously and contrary to the law. Okay, logically, we're most likely talking gross misapplications of the law. However, even in setting aside a verdict, depending on the jurisdiction, the judge then could not enter a new verdict. The judge would essentially have to order a new jury trial. Okay, so that's the primary protection granted by the reexamination clause. Okay, so in generally speaking, under the common law, jury trial is a very sacred thing, and reexamination of facts decided by a jury is a very controversial thing from the get-go. And typically is not done unless you can prove somehow that there was some gross procedural or application error in the law applied during the trial process. All right. Not always easy to prove. Okay. But again, the only typical way in the common law that you will be able to re-examine these facts would be for a new trial to be ordered, either by the trial judge himself or by an appellate court. Okay, so that's the general overview of the Seventh Amendment. Okay, it's not exactly an intensely heavy amendment. All right, this is just the basics to help you understand exactly how that amendment functions. Okay, I'd also like to add before I let you go that unlike virtually all of the rest of the Bill of Rights, the parts made applicable to the states, Amendments 1 through 8, none of the Seventh Amendment has been incorporated to the states. Not one word of it. All right. And as such, none of its provisions are binding upon the state governments. However, virtually all 50 states provide mechanisms for having a civil trial. A jury trial in civil cases, providing that the amount in controversy reaches a certain threshold. Okay. So that, folks, is the Seventh Amendment. And it was largely added to the Constitution to quell the fear of those who felt that the federal government would not be overly willing to allow jury trials in civil cases when it clearly had to offer such protection in criminal cases. All right. As well as the fact that many people also feared that it would check the power of federal judges, who many early Americans felt would very quickly become power trips. Okay, so that's the Seventh Amendment. Any questions, controversies, leave them down below and I'll be happy to answer them. And if you have not subscribed to my YouTube page, I invite you to do so. Your support would be greatly appreciated. Take care, stay safe out there, and I'll talk to you at the next bite. Peace.